If my attorney does something with which I do not agree, can I change it? And are my finances and property protected?
Under the Powers of Attorney and Agency Act, attorneys are given significant scope to make virtually any financial decision that they see fit. This can be restricted to specific documents appointing attorneys if a person wishes. Powers of attorney can be left open to abuse, whether that be intentional or unintentional. Instances where attorneys have abused their role to receive an early inheritance or otherwise misusing the principal's funds with or without malicious intent often occurs where the attorney is aware that the principal lacks capacity or the ability to monitor their actions, and that can have permanent life-threatening impact. However, when this occurs, there are actually limited options to remedy the abuse.
There are various civil and criminal law remedies that exist to deal with the misuse and abuse of powers of attorney. However, in practice, these remedies may well prove ineffective. The victim may sadly have died before the abuse ever comes to light. Alternatively, the victim may be unwilling or unable to testify, or unable or unwilling to make or pursue any complaint. Formal civil action is costly and time-consuming, and the problem of relying on the criminal law is the police may not wish to get involved and treat it as a purely civil matter.
The Powers of Attorney and Agency Act allows for the Supreme Court of South Australia to remove the power of attorney, or for the South Australian Civil and Administrative Tribunal to appoint an independent administrator where it is found or suspected that an attorney has acted inappropriately. Where an attorney has acted inappropriately or has failed in their duty, the principal can apply for compensation for any loss that's associated with that failure or action. The Powers of Attorney and Agency Act also makes it an offence for an attorney to fail to keep accurate records, with a failure to do so resulting potentially in a fine. So a number of practical measures could be taken to prevent abuse before it even happens, and these include things like increasing community awareness of the roles of powers of attorney, ensuring that the principal and the attorney have signed the document with full knowledge of their rights and obligations, only allowing the use of powers of attorney where the appropriate conditions have been met, notifying others of the appointed attorney, ensuring that powers of attorney include statements of wishes which are well known in regard to the management of financial affairs and payment for medical treatments, and finally providing copies of the enduring power of attorney to others, including financial institutions and legal representatives.
I thank you for your interest in this reference and the Institute. Please feel free to contribute to our work via our website and our email that now appears on the screen. Thank you.